Sorry to keep you waiting. I was downstairs putting these microphones on. I'm sure you all have been, it's my understanding you've been prepped, right? I see he's got a lot of things. He looks like looks like my tax case book you know, when I was in law school. Actually, it's a real, I'll just say a few, make some very, very brief introductory remarks, and then I'll let you all take control of our discussion here. First of all, it's a delight for me to be back in Ohio. I think the last time I was in Ohio, I was at Ohio Northern, at their law school, and I had a chance to visit the plant that makes all the NFL footballs. And it was one of the most interesting visits I've had at any facility, to see people work at that speed making footballs for that most important game. But more seriously, it's always good to come in from Washington. It sort of forces me to reflect on what we do on a daily basis. I've been fortunate, as you know, to have been in all three branches of our national government. As someone said when I was nominated, that I was a bureaucrat, and I didn't think he was too far off base. I was a bureaucrat, but it's also given me a perspective on the government that's a bit different from a practical standpoint. The branch that I'm in now, of course, is far different from both the legislative and the executive branches, and it's one that certainly in the other two branches we were not required to write opinions, but it's different in a more serious sense. When I was in the other two branches of government, just in the daily operations, for example, the contentiousness, the nature of the discussion. You've seen enough, I'm so sure, of the way we do business in Washington to understand what I mean. It's how can you discuss something if everybody's yelling, or if they're engaged in these ad hominem attacks? One of the good things about the court is that has not happened. So that even if we get it wrong, at least we treated it as a serious matter. Sufficiently serious so that we control our emotions and our tempers, so we don't trivialize the decision-making process with bad attitudes, etc. So as you ask your questions about the court or about the government, sort of keep in mind one thing. It's the only thing I dislike, and it won't come from you all, is sometimes I see people look at all the institutions with this very cynical attitude that everything is terrible. It's just not that way. A student asked me a few days ago about the cynicism and the cynical attitudes that are so prevalent these days. And what I indicated to that student is that I wasn't cynical. There's no way I could do this job and be cynical. And there's no way I could do this job as a matter of tactics. You know, just one battle after another. It's got to be something more. And I would assume that it's that something more that you all are studying about, the ideals, the principles, the sort of virtuous kinds of conducts that we are aiming at, the kind of society that we would like to have, and the society that the framers wanted to have. Now today, many people will simply say, well, you know, that's all. Someone said the other, I read in, I think in your On Principle, there was an article in there where someone, I don't know who said it, I don't know how anyone could reach a conclusion like that, but they said something to the effect that I was naive. Well, it's not, if I have a choice between being naive and being cynical, I will choose naive, because at least when one is naive, that assumes some degree of being, of idealism. And I think that is far, far more important and significant and beneficial than cynicism. But that's the only thing I said. I don't suspect that we'll have that here, but it's the only thing that's kind of off base with me. I just think it undermines everything that we're for. So with that, why don't I open up to questions, and I'll let you all guide our conversation. Yes, sir.
Justice Thomas, You are certainly well schooled in the founding of our country. Which of the founding fathers do you turn to most frequently for guidance and inspiration when you're trying to decide a tough case?
Oh gosh, I don't have a clue. I really don't. To be honest with you, most of the time we spent, I was reading some draft opinions before I left. And I don't think we referred to the framers once. Most of it's statutory construction. You know, it depends on what you're doing. I mean, I'm a true believer that I let my research carry me to the answer. And a lot of time they're not even relevant to the questions that we're answering. There's nothing said. No one mentioned it. We just had the census case, and to my knowledge, there wasn't a whole lot written about that. And we didn't get to the constitutional issue. It was just a statutory issue, for the most part. So in many instances, you don't even get that far. So I would hesitate to pick one over the other anyway. I mean, maybe as the years advance, I'll be more inclined to do that, but not at this point. Yes, sir.
Justice Thomas, what do you foresee as the future of the Declaration of Independence, politically, in the judicial branch of the government?
The Declaration on, and what do I see? It's not really, I don't know that it's often cited, and we see the Constitution, for the most part, as the expression of those ideals, and usually you're talking about a constitutional right. I think I cited the Declaration in Adirondack. I think it was either Adirondack or Jenkins or one of those, just simply for the notion that to sort of refute a notion that the government has any role in making us equal. I think that's what I cited for. That's been like 4 terms ago. But I think it informs, as I said, and I've said for years, it informs the Constitution. I think sometimes to have a full understanding of it, you've got to have some understanding of the Declaration. And with that, I think there are many people, I think, who start there and then simply go to the constitutional analysis, the actual document itself, the actual provision that you're dealing with, as opposed to then having to go back and cite the Declaration. They just simply stop at the provision of the Constitution, the article or the amendment or the clause that's involved. Yes?
Justice Thomas, I was wondering if you might comment on the founders' understanding of the role of religion and morality in a free society.
I think I might pass on that one. That's a good question, but I have joined some opinions that pretty much suggest my own approach and my disagreement with some of our Establishment Clause jurisprudence. You know, for example, I've joined opinions calling for the overruling of the Lemon test and suggesting that our Establishment Clause jurisprudence is too restrictive as far as the government having any involvement with religion. But I prefer not to go beyond that, because it tends to compromise your ability to sit on those kind of cases in the future. It's an excellent question, though. Yes, sir.
Justice Thomas, you're in a uniquely powerful position because you don't have to serve just one term, you're on there for life. What is, like, if you can say, how are you going to take advantage of that, or what is your goal for, your life term, that you can affect the Constitution in our country in powerful but unique ways?
I guess I never think of myself as that powerful. The last person, there was a student who called me powerful at a Missouri university some years ago. And his argument was that I was so powerful that I could do anything I wanted to do. I didn't have to be limited in any way as a judge, because I was just powerful member of the Supreme Court. And so I told him he was expelled from school. He said, well, you can't do it because you're not president of the school. I said, but I'm a powerful member of the Supreme Court. And so you are expelled. But I guess I don't have any goals other than deciding these cases. I mean, I don't think you can have an agenda. I would be a bit fearful if a person who's is authorized to make decisions in cases, specific cases, has an overall agenda. In other words, using cases to do something larger than the cases themselves. I'd be a bit afraid. I would also be a little bit afraid of someone who relishes the opportunity to make judgments about you or make judgments about the country. If anything, I think it works the other way, that it's a bit humbling to be called on to make these judgments. You feel the need to think things over a little bit more. You have less of a tendency to be glib about it because you know that whatever you do, it's going to have an impact on somebody. So you wind up thinking and rethinking and turning it over quite a bit. I'm not saying that I second guess myself, but there's some problems that you continue to think about quite a bit. But I have no overall plan. Yes, sir.
Justice Thomas, what influenced you to study law and devote your life's work to influencing it and working with it?
Oh, goodness. Well, I think first thing is I failed at being a priest. I never made it that far. I had my own reasons. I wanted to go back to Savannah and participate in righting the wrongs there. And you know, we have those dreams when you're 18, 19, 20 years old. And I was actually still on my way until I was nominated to the D.C. Circuit, and I thought it was time to unpack the boxes. But it was a dream that motivated me. And I think that there's got to be a little bit more. I guess at some point when I was 30, 31 years old, I sat down and I tried to figure out what would motivate me to make an effort every day, to get up and really want to do something, or to do it even if I didn't want to do it. And the bottom line was that I had to do something that made a difference in the society in order to preserve the freedoms that we have, and to engage in the debates that would govern our lives or affect our lives. Little did I know it would wind up taking me to the Supreme Court. That was not in the cards. In fact, being a judge wasn't in the cards until a friend of mine brought it up in late 1989, after President Bush was elected. And then I started thinking about it. But the whole idea was to do something that helped preserve individual liberties. You know, we can argue. People argue self-interest in a way that it sounds as though they're talking about freedoms, but it's self-interest that you're arguing about. There are policies that I can argue for that would serve my self-interest, but it's not freedom and it's not liberty that we're talking about. Liberty would have to be inclusive of us all, not just a group. Yes?
Justice Thomas, as a prospective law student, I'm interested in what it's like studying at Yale, and also what other law schools you recommend, particularly ones that still may embrace natural law principles in their teachings?
Oh, gosh, I don't know. Yale was fine. I had no difficulties with Yale. I made some very, very good friends at Yale Law School. The group that with which I associated during law school, study groups, were excellent. I still have some very dear friends I made there. I have some fundamental disagreements with Yale subsequent to that. So I don't consider myself particularly close to Yale Law School, but that is not because of the way I was treated when I attended Yale Law School. It's a fine institution. And I still hire law clerks from Yale. But I hire quite a few, and let me just say that there are a number of schools that are excellent. As I said, I visited Ohio Northern, and I thought that was a fine law school. And schools like Pepperdine, from what I understand, I can't name them all. there's some that I'll miss, but I'm sure University of Chicago. It's an excellent law school. Notre Dame. I've got, I'm sure there are others. But I have clerks this year from Chicago, from Yale, one from Texas, and one from University of Virginia, which is an excellent law school. And I have one coming from Kansas in a few years, young woman. And I've got one coming from NYU in a few years. So I think that I think you have to just search carefully, and I think that you look for more. I like traditional legal education. I don't like the sort of fringe courses, the law and courses. I mean, law and economics is probably fine, but I like sort of the meat and potatoes course. And I think that with this kind of grounding that you have in the origin of the founding and the history of our country and the framing of the document, the most important document in our government, I think you're going to do just fine. I wish I'd had what you all have. I read the brochures and I said, sign me up. I found myself filling out the application, you know. Then I realized I didn't have the grades to get in.
I'm sorry, let me explain that. You could have gotten it.
Is that right? Yes.
Justice Thomas, what thinkers and writers have most influenced your personal ideologies that you use when you rule on cases and things?
Oh, goodness. What thinkers and writers. Oh, my goodness. That's a tall order. I can't really say. I've read them all. I've been influenced one way, either positively or negatively, by all sorts of people. You know, I was, for years, I used to drive Ken Masugi, who's a great friend of mine, and worked with me when I was at EEOC. Drove him nuts that I liked reading Ayn Rand. And, well, he got upset, but I still like it. But during the 80s, we also had Paul Johnson's Modern Time. I thought was just something, just to get an understanding of the nihilism in this century. I thought it was just really, really important. We did a lot of discussion of Harry Jaffa, who's certainly been influential among the Straussians. We have, I'm trying to think now of some of the others that I've written recently that were very important. Well, let me think about it as we chat, and as I think of them, I'll mention them to you, because there are others, but I don't want to mention those people who were interesting but weren't particularly that influential. I would have to mention at the top of the list, for me personally, on any variety of things, I'd have to mention Tom Sowell. Without his book, Race and Economics, I don't think that I would have begun to think about a lot of the problems confronting our country, and certainly minorities in the country, in the way I did if I had not seen that book in the mid-1970s. So I would have to put him right at the top of the list. Also, he's a dear friend, and he's a prolific writer, and he writes about a book a year. So let me put him at the top of the list. If I think of others, let me mention them. Yes?
I have a question of a mechanical nature. How much of your own work do you do for the court? It's been mentioned that the law clerks have a lot of control and a lot of power.
Yeah.
How much of your own?
I think the law clerks are in charge of everything. In fact, I got an allowance from them before I came here. I think law clerks are like anybody else. My law clerks are wonderful. I always love those theories because I see my colleagues. I don't know what goes on in their chambers. I know they are consistent over the years. That is, that the law clerks change every year, and yet their work is consistently every year. So it can't be the law clerks. Law clerks are like anybody else. They're employees. The things you ask them to do. Mine are like family, and I think that may be true in the other chambers too. I'm very close to my law clerks. They're the people you talk to. You rarely see the other members of the court, but you see your law clerks every day. I have 2 law clerks who are Catholics like myself, and we go to daily mass together. and have breakfast, and we chit-chat about a variety of things. So I just say that to underscore the fact that it's more than just employer-employee. We in my chambers discuss every case together. 4 law clerks are required to be aware of all the cases, to do bench memoranda, to read them, to think about it, and then to discuss these cases and participate in the decision-making process. In my chambers, as probably the custom in many of the others, I can't speak for the others. We have a system where the clerk who is responsible for the case always does the initial draft. Then we have a vetting process that's quite extensive for redrafting. And ultimately, all the final changes, the final calls, the direction. We also I have an outline of the decision before we start. So each of the clerk has a roadmap of how we're going to do something if we're assigned the opinion. But clerks are an integral part of what we do as far as them having power and controlling things. I think that's something that exists in people's mind. But it's, we don't spend a lot of time trying to refute it. I think that the court and the seriousness and the personal involvement of the members of the court is, as far as I'm concerned, it's the best I've seen in government. And in all 3 branches, it's absolutely astounding to see people who know so much about these specific cases. Yes.
You mentioned that your relationship with the law clerks here, and I was wondering if you could further talk about the relationship you have with the other justices and how you work together with them.
On the other members of the court, of course, we see each other formally when we have conferences. We normally have conferences on Fridays for our cert petitions, and when we're sitting, we decide the cases that we hear on Tuesday and Wednesdays. We decide those on Friday mornings. On those days, we're together. Then when we are sitting, obviously, we are together. But beyond that, the only informal time that we have together is that on our work days at conference or court, we have lunch together, and that's on a voluntary basis. It is very warm, very respectful. There are no cliques, there are no cabals, there are no little work groups that sneak off and conspire against other people. It is very independent. Each member of the court, I would say, would do his or her work, and that you circulate the documents, and people join or they don't join. Occasionally, someone might call you and ask you to think about something or would want to chat about something. But by and large, it's done in writing. But it's very respectful. People don't intrude on your time. For example, if they have a need to come by, they will normally call and ask they won't say, "Can you receive me?" But they will, it's pretty close to that. And then they don't waste your time by hanging around. Has it ever happened to you that you got work to do and somebody comes and hang around?
All the time.
Yeah, I tell you. They do it all the time?
Oh yeah, there's always people that are trying to keep you from your studies.
Yeah, well, turn off the phone and lock the door. That solves that problem. And just tell them, I don't like anybody. Put it on the door. Or go away. Those short words like that. Yes.
Would you comment on the hyphenated American? Do you think that that's more divisive, or is it helpful in maintaining an ethnic identity?
Well, I don't know. I am black. I'm an American, and I'd sort of like to keep it that way. I don't hyphenate my name. I don't hyphenate where I'm from. I really don't get into that debate very much. It's not something I found particularly useful. Yes, sir.
You talked about your law clerks and working with other justices. Well, when you and the other justices reach a decision, how do you go about forming your opinion? How do you decide which justice is going to write the opinion or the dissent? Basically, what process is involved?
That's a great question. We vote let's go back to the conference. And it is a conference because, I mean, it's actually in a conference room. And we sit at a table much like this, but it's different. It's, if you ever saw that conference room, it's really quite elegant. And you're quite humbled. I don't think there's a time that you go in there that you don't realize where you are. It's not like perhaps going into one of the great cathedrals of Europe, but you really understand how important it is. The minute you walk in there and you see the green top on the table, we have assigned seating. So at this table, I am sitting where Justice Stevens sits. The Chief Justice would sit at the other end. And Justice O'Connor sits here. This is by seniority. Justice Scalia, Justice Kennedy. Then we start on this side of the table, the other side of the Chief Justice. Justice Souter. Then I'm next to Justice Souter, Justice Ginsburg, and Justice Breyer. There are 4 on the junior side of the table, 3 on the more senior side of the table. We vote in the descending order of seniority, starting with the Chief Justice. The senior member of the court in the majority decides who writes the opinion. That's usually the Chief Justice. From time to time, it's Justice Stevens, if they're on opposite sides, and he's in the majority. And occasionally, it's Justice O'Connor, and even with less frequency, Justice Scalia. But that is normally done, if it's the Chief Justice, the Monday following the final 2 weeks of our sitting. And that is based upon whether or not people have gotten their work done, which is normally okay. And, of course, the Chief Justice figures out, I guess, he's got a formula of some kind. And if you run into him, ask him, because I won't. And we wonder how he makes the assignments, but he's a fair person, and you'd never hear any grousing about the assignments. He's just above that sort of, there are no internal politics about the assignments. Once you get the assignment, you draft it in your chambers, and then you circulate it. You've been to conference, you've seen the vote, you've heard the arguments, and then you draft. If you're drafting on behalf of the conference, you try to capture the consensus of the conference. You're writing on behalf of the court, not just for yourself. And then you circulate it to the court, and people will make comments, ask you to make changes, question certain parts of it. Once you get all that straightened out, and you've got a court, say you've got 5, 6 votes, or 7 votes, whatever the alignment was, then perhaps someone might write in concurring opinion. They might concur in the judgment, but not your opinion. Or they might dissent from the judgment and your opinion. And then there's a little back and forth. When all that's done, we hand the opinion down. And it sounds a little messy, but boy, it works. My first term on the court, I said, there's no way we are going to get this done. But every year, it all works out. Yes, sir. Yeah.
What is it about you that has brought you to this point and to the position of justice?
You mean the court? Oh, I don't know. Gosh, I don't know. I don't have a clue. You know, there are people who seem to know, to look at your life in retrospect and can figure out how you got from this point to that point. Well, having lived it a day at a time, I don't have a clue other than what I've attempted to do in each position I've had, or in school or elsewhere, is simply do what I was supposed to do and do it the best I could. You know, and recognizing that you make mistakes or things like that. And at EEOC, I mean, there's no tradition, certainly, of anybody leaving EEOC and even becoming a judge. I don't think there's one federal judge who'd been chairman of EEOC. And yet, it just happens. And I think part of it is that to have someone who has confidence in you, like President of the United States, and then to be able to withstand, I guess, whatever opposition occurs or takes place. But again, I can't take much credit for all those things. I just simply did what I was the best I could do with the positions that I had. I mean, and tried to do them honestly. That was school. That was my job at Monsanto, the Attorney General's office in Missouri, at education at EEOC, and let the chips fall where they may. And things seemed to work out. But it certainly wasn't. I'm a lousy career planner. You know, I tried to map things out. I was going to be a millionaire by the time I was 30, and I was in worse position at 30 than I was when I was in law school. I was farther away from being a millionaire, you know. But I'm a lousy career planner guy. I just sort of do the best I can. Yes, sir.
Yes, Justice. I'm a very big supporter of the pro-life movement, and one of my foundations of my argument is natural law. And I was wondering if you could comment on natural law and abortion.
No. They tried to get me to do that during my hearings, and I haven't done that yet, and I think I'll leave it at that. I have joined the court, the dissenting opinion in Casey with respect to, I think the Chief Justice. I think Justice Scalia may have written also. I think I joined both of those, dissenting from the majority.
You did, I have it right here.
Yeah, but I'll leave it at that. Way in the back, yes.
Yes, Justice Thomas, I was wondering if you could comment maybe about anything in the structure or operation or the decision-making of the court which renders the court to be a democratic institution in a position to protect civil rights and civil liberties?
The court is not democratic, and it's not designed to be. The other branches are democratic. I assume you mean majority rules. There are many things that there's a sort of a counter-majoritarian push. If you had a vote, for example, on segregation, which way do you think it would come out in 1950? Or if you have a vote on certain disfavored religions, where do you think it would come out if it's majority rule on everything? I don't think the court that's the odd thing. I hear people talk about, say that the court should be representative of the population. Where does that come from? The court is not a part of the political branches. The last political thing that we do is to go through confirmation. And since I've been on the court, there's been no political discussion. The only time there's been anything that approached political discussion has been sort of a pool, a betting pool on how many electoral votes will be won or lost during a particular election. And that's sort of just a modest, nominal kind of thing, just to get. Well, one year I did pretty well, but I'm not good at politics, so. But it's just the court is not a part of the political branches, and it's sort of bad when I see it reported as though it is. It simply isn't, and there's no political discussion of any sort that I can remember. There may be reference to what's going on in the papers, but that's about it. Yes.
Justice Thomas, you've received a lot of criticism from the legal community at large, and specifically from the black legal community. I was curious on whether that frustrates you, or if you just took it as part of your position, or how you view that criticism.
I pay no attention to that. You know, it's less than you really think. I mean, what happens is there are people with their various axes to grind who amplify it. You know, I think that, for example, I was down at the National Bar Association this summer, and they made it seem as though there was some war down there or something, but it really wasn't. You had a few people who were using their First Amendment right to disagree. The unfortunate thing about it is that much of the discussion has to do with the notion that because I am of a certain race, going back to the previous question, because I'm a certain race, then it's preordained what my views should be. You know, for example, it is although I may be with a majority of 5 on a particular case, well, you should know better because of pigmentation, not because of your thinking processes, but because of your skin color. And I find that highly offensive. And those kinds of criticisms don't merit response. And just as the criticisms that were founded in stereotypes when I was a kid did not merit response. See, I've had the misfortune or good fortune to remember segregation when you did have those kinds of stereotypes, and they're all basically the same thing. That's because you are a certain pigmentation, these are the things that I can predict about you. And today, that prediction includes how you should think. So everyone here has a right to make up their own mind, except for those who are of certain ethnic groups. Here's what you're supposed to think, and I have nothing to do with that. Yes, sir.
Justice Thomas, do you feel that today in America, we are freer than we were at the framing of the Constitution? And with each Supreme Court decision, do you feel that Americans' freedoms are enforced or, in a sense, lessened?
Oh, I don't know. That's a pretty big question. I think government's much larger. And I think that I've disagreed in any number of cases because that's, I think it's anyone who is concerned about individual rights and civil liberties has to be concerned about the size of central government. And if it was a part of the arrangement that government would be kept limited in order to preserve those liberties or to prevent any kind of coercion or force, then you have to be concerned about the size of government. I know in my lifetime, let's just get away from the framing a minute. In my lifetime, I've seen more influence of the national government. That's what Lopez was all about. That's why I took the time in Lopez to write extensively on how far the Commerce Clause has come and why we should revisit it and what it's doing. That's why I take the time to try to write on dormant Commerce Clause on federalism issues, as I tried to do in Jenkins, or the role of the courts in a case like Jenkins or Casey, the Arizona prison case. So my concern is with the role of national government and the effect that will eventually have on the arrangements that the framers came up with to protect our liberties. So people can differ, but I tend to think that we have moved farther down the road than we should have. Yes, sir.
Justice Thomas, what process do you use in choosing law clerks?
What process do I use?
Yes.
It's pretty informal. First of all, I only choose law clerks who have clerked on the Court of Appeals, Federal Court of Appeals. That's the only preparation you get for our court, because there's no real time to learn. You got to hit the ground running. And the federal courts give you a chance to do that. Then I usually look at recommendations from the judges. There's certain judges who are friends of mine that I tend to go to. And you look at class rank. That eliminates a lot of kids. Because you really don't, schools at rank, you don't get much. I mean, the kids I tell you from Virginia, #1, from Texas, #1, and they're usually in single digits in class rank. Then I pick the kids I like. I don't want everybody the same. I don't want a bunch of people walking around, making me uncomfortable. I like kids. I mean, I like people who are alive, who have energy, who believe in something, who have good work habits, who know how to take criticism, who know how to give constructive criticism, who are mature, who are self-starters, and who are fun to be around. I mean, this is family. You're picking a family for a year. And I'll tell you, my clerks have been great. My clerks this year, I love being around my clerks. And they're smart, energetic people. They keep you energized. You know, they're closer to you in age than they are to me. And it is absolutely a delightful thing to do. It's the best part of the job because I can rethink everything. We sit around and I can rethink. They can criticize some opinion that I've written before because I'm trying to rethink it, trying to look at it again. They can show you where the flaws are. They can disagree. Can disagree with each other, you know. But then nothing can leave that room. It all must die there. And we all have to go to our graves with that. It's part of making the sausage. So, and they have to be intellectually honest, and they have to be honest people. You cannot have dishonest people in that process. You simply can't. And you'll find it later on in life that when you're doing things that are very, very sensitive, and you're working out all the problems in it, you cannot have people who are intellectually dishonest, and you cannot have people who are not conscientious, and you cannot have people who are just plain old dishonest, who are keeping notes, who plan to leak things, who are talking to people about. I don't talk to my wife about these things. She's my best friend. You know, she doesn't know which cases I'm working on. I mean, she knows from the public standpoint, but I don't tell her how we're working through these cases or what somebody said at conference. I can't do that. And if I don't tell her, they can't tell anybody. You know, because we're not supposed to. It's just wrong. It's breaching a confidence that we owe to you all. Yes, sir.
A lot of cases are offered to the Supreme Court. Is there any general criteria you look for in the cases in deciding what to choose and what not to?
Well, in most of the cases, you have no right to come to the court. You have to petition us. There are very few areas where we have direct appeals. Now, we receive between 7,000 and 8,000 petitions a year. And this year, I think we'll have between 80 and 85 cases for full opinions. So you can see what the percentages are. Normally, the criteria we use are whether or not, obviously, it's got to be a federal issue. We can't intrude in state matters. It has to be a matter of some importance. It can't just be some small issue. It's got to be some significant federal issue. And finally, we normally look for some confusion, some disagreement among the state courts of final resort, say the Supreme Court of Ohio, and our federal courts of appeals. So let's say 6th Circuit and the 7th Circuit don't get along. You're in the 6th Circuit here. They disagree with the 5th Circuit and the 4th Circuit and the Ohio Supreme Court and the Arizona Supreme Court. So we call that a split. Significant federal issue, a split among these courts. That we will then consider that. That's the kind of case we're looking for, assuming no procedural or jurisdictional problems. Then we go around the table. If 4 members of the court vote for that and reach the same conclusion, that it is an important federal issue, there is a significant split, then the case comes out of court. And there is, again, I go back to on the merits, the cases we decide after argument, as well as the cases that we accept, the petitions. You rarely talk to your colleagues before you vote. Occasionally, someone might call you, but that is very rare. So you walk in the conference not knowing how anybody else is going to vote on these cases, except perhaps the person who put it on the list. We call a discuss list. And you might guess that that person's going to vote. He or she may have changed his or her mind in the meantime. But again, you do not have these pre-meetings. It's all independent. Yes.
One more question.
Yes. Yes, sir.
You seem to, I'm sort of inspired by the way you really like, you said meat and potatoes before with education, and you really seem to hold the Constitution and the core principles of the government in the United States in high regards. It's sort of inspiring to, I mean, you talk about you're awestruck every time you go into the conference room, and it's just really inspiring just to walk into the room with all these powerful people. I mean, if I wanted to play powerful again.
Yeah.
It just seems like a great opportunity to just...
Well, I go back to the word I used before, and I really follow Justice Powell who is a wonderful, wonderful man who just recently passed away. In many instances, I think you have to go in sometimes thinking you're really not worthy to be there. I'd really worry about someone who goes in who says it's about time. You know, it's like to think they're an NBA basketball player or something. You know, they're doing all this kind of stuff. You know, doing just all these crazy things. You know, really, really happy with themselves. I think that it's it's the kind of thing that you're called upon to do, that others may look at as a powerful position, that I think the people who do it have to be, I think they have to feel that they are not as large as the institution, that they are part of something very important. It would be as though, I don't know how many people who, if they're saving someone's life, would take the time out to say, well, boy, I'm really good. Did you just see that mouth-to-mouth resuscitation? That was done properly. Instead, they're concerned about what they're doing, and they're glad that they're competent enough to do it well. Again, so it's just, I think it's a humbling experience. Yes, sir.
Do you refer to yourself like more as a collective then, instead of like an individual up there? You're sort of a collective team that's just sort of, the issue comes first, and then you're not really an individual that's trying to, you know, get
I
your
think I
point.
said just the opposite in the decision-making process, that you act as an individual, and you come together and you vote. Then when you write on behalf of the court. When you write separately, you're writing for yourself, but you can't control anything for yourself. I mean, I can write all I want. That controls nothing. Only the court can write a decision that has authority. And you write on behalf of the court, and it says that, for the court. So, again, going back to your other point, though, it is very important to understand that anybody who relishes deciding big things about our country or other people's lives, I think ought to be watched. I wouldn't want anybody relishing to make these decisions and get a thrill out of it, you know. Oh, boy, I really love that one. You know? No, I think it's more, and you know, I noticed one thing that happened during my years on the court is really fascinating. I look at the pictures, my official picture, and my hair isn't really great. It's a specular gray in it. And you really, after a while, you look at your hair, everybody's hair turns white. You know, and some people say, yeah, that's all those wrong decisions you make. But I think it's the gravity of the position sometimes. It weighs on you a little bit more than you think it does. So, but it's beyond that, on a more positive, light side, it is a wonderful place to work. We have a wonderful library, wonderful staff. The Chief Justice is absolutely fabulous. The colleagues are wonderful. It's just a fabulous place to work. It's a place where we don't devote a lot of time to all of these extraneous things, you know? So if people are wrong, it's not because they're distracted, and it's not because they don't have any help. It's just because they're wrong. So, thank you all very much.